Uh, Everybody, I'd like to make a motion to open the meeting.
So moved. Second.
All in favor?
Aye.
Okay, the noted, and, I'm gonna break it up, and I'm gonna read the first, public hearing. The application of Sophia Dolinar, 66 Summit Road, Tuxedo Park, New York, tax map number 104-1-11.1, in connection with her appeal of the building inspector's determination issued on July 3rd, 2024, that a building permit and the architectural board of the Board of Architectural Review is required for no trespassing signs and security cameras installed at the property, and that no signs are permitted in the village. Do proof of mailings?
The Delaware application, there were 3, 4, there were 10 notifications sent to the immediate neighbors, and 5 proof of mailings were submitted.
Okay. And who's going to present for the applicant?
Good evening, Mr. Chairman. Members of the board, Robert Cortioso with the law firm of Snyder and Snyder on behalf of the applicant. Where would you like me?
Right there, it's fine.
This is an application that is an appeal of a determination of the building inspector. As you noted in the public notice, it is essentially twofold. The building inspector made a determination that no signs are permitted in the village, number one, and number two, the posts that have been installed for the purposes of having no trespassing signs and security cameras require BAR approval. We're appealing the determination for a number of reasons. We've submitted a petition with a number of exhibits. We've submitted photographs. We've submitted a set of plans that show the location of the posts with the no trespassing signs and the proposed locations for those security cameras. The purpose or need for the no trespassing signs and the security cameras, I don't know if that's necessarily relevant to your determination, but I'd like to explain it anyway. Ms. Dolinar has been sued by her adjoining neighbor. He's claiming a number of different items in his lawsuit. Number one, he's claiming that he has obtained a prescriptive easement over a portion of her property, which is at the end of East Summit Road. And the way you obtain a prescriptive easement, if you're not aware, is you use it, someone else's property. You have to show a number of factors, including that it was hostile, that it was open and notorious, and that it was over a period of time. So it's very important for Ms. Dolinar to understand who's on her property, when they're on her property, and be able to document that. It's also very important for her to be able to document the location of her property line so that people do not either accidentally or purposefully trespass on her property. The second thing her neighbor is claiming in the lawsuit against her is that she does not have access across a common driveway that we believe is a false claim. The common driveway was established pursuant to a map that's on file with the county clerk, and we're litigating these issues. So because of that, and because of past trespasses, conceded trespasses, continued trespasses, it's very important from a legal and from a safety standpoint for her to be able to protect her property, be able to know who's on her property, be able to give notice that it is her property, and be able to give notice that trespassing is not allowed. So with respect to the determination of the building inspector that no signs are permitted in the village, we believe that's incorrect for a number of reasons. First and foremost, there is no code provision that bans signs in the village code that we're aware of. I've done the research of the village code. There's nothing in the building inspector's determination that cites to a provision of the village code that bans signs. Secondly, there are numerous signs within the village, both public and private signs. We've documented that with a number of photographs by way of example that are part of the package. There are numerous signs in the village. So if there was a prohibition, I would assume that those signs wouldn't be permitted either. And third, and maybe most importantly, it would be a violation of a residential property owner's constitutional right to free speech to be prohibited from being able to have signs on their property. And we've cited to various case law. Now, municipalities may enact time, place, and manner regulations related to free speech to limit free speech under certain circumstances. But because there are absolutely no regulations and because the interpretation is that there's a total outright ban on signage, that would be a violation of the First Amendment. So we believe that the village code does not prohibit signs. There's no code provision. And if it did, it would be a violation of our rights, and therefore any determination in contrast to that would be arbitrary and capricious. Secondly, the issue of the posts with the proposed security cameras that are also intended to hold the no trespassing signs. The code provision that's cited is section 100-53, and it talks about things such as, typical construction. And it goes on to say any other activity that alters the property's appearance. And that's the code section that was supplied in the building inspector's determination. We believe that the limitation on any other activity that alters the property's appearance is unconstitutionally vague. A person of ordinary intelligence cannot reasonably understand when a building permit or BAR approval would be required based on that. What does that phrase mean? What does any other activity that alters a property's appearance? Does that mean if you change the color of your house? Does that mean if you change a shingle on your house? Does that mean if you put a sign on the outside of your house that's a decorative sign? Let's say it's even a thermometer on the outside of your house. Does that change the appearance of the property? Does landscaping change the appearance of the property? Does doing anything on your property change the appearance of the property? That would trigger the need for a building permit and BAR approval. I'd submit to you that just has simply not been the practice in the village. That's not been the case, and that to enforce that vague provision would be unconstitutional. And therefore, we're asking for a determination that BAR approval is not required, at least not as the code is currently written. With that, Mr. Chairman and members of the board, I'd be happy to answer any questions you may have.
Lisa, would you like to clarify?
Yeah, I would just like to clarify that this board is not going to pass on the question of whether that provision is unconstitutionally vague. What the board will pass on is whether or not Mrs. Deliner needs to go to the BAR for approval of the signs. And I have advised my board that under 100-54 criteria for BAR review, it specifically points out signs. So to that extent, I think this board will take up that matter and make a determination. I've also advised my board that I do agree with you. I see no code, no zoning law that prohibits signs. So I think that, in that case, I think that you are correct, although I think that's more of a village board policy issue that John can speak to or the village board can speak to. But that also won't be in front of this board essentially because there's no zoning law that this board can either alter or grant relief from. There's just nothing in the zoning law that says that. So I think to your first question about that, the board, under my advice, is going to say really there's no support for that in the zoning law. As for the second, yes, the board will consider the 100-54 criteria, but it will not pass on constitutional vagueness. That's really a question for the village board and not for this board.
So with that said, one of the things I want to make sure that we do have clarification at the end of this process on is whether there is a prohibition on signs or not, just because the determination says there is a prohibition. What we wouldn't want to do is have to go to the BAR, where we have filed applications, we have pending applications, and then be told that that no, it's prohibited, and therefore we would need quote unquote a use variance from the zoning board. So I want to make sure when we do, if we do go to the BAR, that we have clarification on that point.
Yes, and I think that this board can provide that.
Thank you.
It will provide that, but it won't pass on any constitutional questions.
Happy to answer any questions the board members have.
The security cameras themselves, there's no determination about whether they are allowed or not allowed, right? And there's nothing in the code that says they're
I
not allowed or
don't
allowed.
think there's anything in the code, and frankly, I do think it would be a problem to prohibit
Yeah, yeah.
security cameras on someone's property. I think that that's not an unreasonable request. And again, I don't see anything in the code that says no signs, no security cameras.
But that's really a BAR issue, not
is a
a
BAR
zoning
issue,
issue.
yeah.
That is not a zoning board issue.
Right.
I have no other questions.
No questions.
No.
I then would like to make a motion to open the meeting to the public. Okay. Is there anyone in the public who would like to speak? That for some reason, they're having issues with,
It's preferable you be.
yeah,
heard up.
it works in here, but people online can't hear you.
Okay.
Best if it's best if you stand in front of the podium.
Chairman, members, my name is John Sarcone, 2 Westchester Park Drive, White Plains. I'm here on behalf of Mr. Flazzoni. I was shocked when I received this letter and everything that was attached to it, because in 27 years of being a zoning planning attorney and having sat in Elisa's seat, I've never seen one like this, because it's not an application for a variance. Is it a use variance? Is it an area variance? What is it? So I'm glad to hear right off the bat that this is not being considered by this body. I would have to say that, since the members of the public are listening, to have to put signs up everywhere, every property in a place, you put a sign up, say, don't trespass. Does that make any sense to anybody? You don't trespass. It says no trespass. And the other thing is, all due respect to Mr. Guadioso, there was a litigation, and when we went to court, the judge asked us to go out and resolve it, and it was to resolve it in a manner that Mr. Guazzoni proposed. So we are almost there. By September 10th, we will be there to resolve the matter, and all the parties have to be present. So I'm happy to say that matter is nearly over with. So thank you for your time and your deliberation.
Anyone else from the public speak?
Yeah, if you don't mind, can you hear me? I'd like to say a word.
Okay,
Can you hear me?
we can hear you, Claudio.
Yeah, first of all, I'd like to comment on the fantasyful miscategorization by Mr. Gaudioso of this issue. We are merely trying to keep a footpath open, which has been open for over 50 years, and that Ms. Delliner, over the past 6 months, decided to close on the village, all village residents, which were using it. When I first moved here, there were 2-3 people every day using that footpath to get from East Summit Road all the way to West Summit Road. People walk their dogs, people would walk their children, and it was a proper footpath. And we believe an easement, a prescribed easement exists on that footpath, and it should be left open to all residents of Tuxedo Park. Now, my neighbor, Ms. Delliner, disingenuously thought that, hey, she was turned down to build a fence across East Summit Road to keep the residents from using the footpath. But she thought, hey, if I put up 5 or 6 signs close enough to each other, I can stitch them together and make them into a fence, which is exactly what she did. I don't know if you went around and saw the property, but she stitched 5 or 6 signs together, and therefore people are no longer using it as a footpath. She might as well been, using American flags all next to each other and declare that, she's not allowed to exhibit her patriotic right. Fact of the matter is, we're trying to keep a footpath open for the public, which has been open for the past 50, 60 years. And we've asked the court for a declaratory judgment, basically asking their opinion. It was a footpath, it's been used, and what is your opinion? And we'll all stand by what the court has to say on Tuesday. Thank you so much for giving me an audience.
On either.
Yeah, I'd like to respond to a couple things I made, Mr. Chairman. First off, in response to Mr. Sarcone, this is an appeal. This board has the power under both this village's law and New York State's village law to hear an appeal of the building inspector's determination. Period. This is a proper application in that regard under both New York State law and village law. Secondly, and ironically, he complained about the signs. And he said, why do we need signs? It was Mr. Gauzoni that posted trespassing signs first and continues to have them up. As most recently as a half an hour ago, because I saw them myself. The pictures of them are in your packet. In fact, he posted one right on his property line, right across from Miss Deliner's area where she sits outside her kitchen window. And he posted those first to sort of stand up here and say that we shouldn't have signs, people know not to trespass. His own client posted those signs first, and it's in your package. It's documented, and I saw it as recently as a half an hour ago. Third, as far as confidential settlement discussions before the judge, I'm appalled that he would discuss that with this board in open session. We were in judges' chambers. That's confidential in nature, so I'm not going to address what was said and what was not said, but we do not have a settlement. We are not close to a settlement. And that's completely improper against the rules of ethics to stand here and tell you about those closed-door sessions with the court. And then finally, as far as Mr. Gauzoni's comment that he sued for a footpath, you have a copy of the papers. That is a lie. He sued for a prescriptive easement 25 feet by 50 feet in size to specifically gain access for his trucks. That's in the papers. That's what he's told the court, not a footpath for the residents of the village. So I'd like you to take note of that in your record. Thank you very much.
Yes.
I'm an old parkie. Since the 1950s, we've been walking that path and down the hill and around. And it's been open all these years for all of us to walk around. I've been actually rode a bicycle around it a couple of times. I had no idea this was a problem with somebody, but it has always been an open path, that narrow little roadway there. And when I went up to Claudio's house a couple of weeks ago, or a week and a half ago, I guess, somebody blocked it off with some signs. And I found it very strange because growing up here in the park, when we all rode our bikes around all over the park, that was an open village pathway. I will now shut up.
And it wasn't a
It's that
problem.
it's
It wasn't a problem until Miss Deliner was sued by Mr. Gauzoni to try and take a portion of her property. It was never a problem. She never blocked it until she was sued in court, had to hire an attorney.
this is really not a matter.
That was stated on the record. I have to make it clear why those signs were put up. And I think that's very important to understand.
I understand the need to establish a record. I just want to note that that really isn't relevant to what you're
Right.
here tonight to decide, but thank you for your comments.
So, Jake, just out of curiosity, there's the 100 steps that probably bisects maybe 10 or 15 properties. There are footpaths, there are gravel paths, there's ski paths, there's all kinds of paths. If we start going down this road, if I live here,
You're right.
Yeah.
Thank you.
I agree.
so I hope these two neighbors can come together and figure it
It's not relevant for this board.
It is relevant because if she.
No, but it's not relevant for this
Yeah,
board.
yeah, got it.
Okay. Like to make a motion to close the public hearing if we have no other comments to be made?
Mr. Chairman, since Mr. Guardiosi took it upon himself to attack my integrity and credibility, I'll remind him that there's a transcript from the court that says exactly what I told you. And he opened the door when he came in and said they're in litigation, which was also improper and I think was misleading. So I just wanted to clear that up.
Okay. Public hearing closed?
Yes, you made a motion. Did you get a second?
Second.
Yeah, I
Yeah,
did.
okay. Board discussion? I mean, I see no reason.
Could you just summarize what we're actually being asked to opine on, please?
Elise, would you?
Yeah, so the board is being asked, first of all, or first or second, whether or not to uphold the building inspector's determination that was sent to the applicant that there are no signs allowed in Tuxedo Park. I can find nothing in the code that actually says that. So this board would then decide whether or not to uphold John's determination. Now, certainly, the village board can always enact legislation that says there's no signs, or if there are signs, they're regulated in some fashion. But there's nothing in the zoning law that says there are no signs. So there's nothing to interpret or grant a variance from. The second thing that you're being asked to determine tonight, and I believe that you have the authority to determine, is whether or not the applicant must go to the BAR for approval of the signs. And that really speaks to 100-54, which is the criteria that is given under the code to the BAR as they review applications. It does in fact specifically say signs. So you might take that into consideration in making your determination. Did that answer your question?
Yes, thank you.
Elise.
So basically, to summarize what you just said is, the only thing we're being asked to determine is whether this should go to the BAR or not. Is that succinct enough, or is it?
Yes, that is the interpretation that you will be making tonight. Should it go or should it not go? So
Okay.
John determined that the applicant should go to the BAR. You will either uphold or reverse that determination. The second thing you're being asked to opine upon, and I think that's a reasonable request since they may in fact appear before the BAR, is whether signs are permitted. Under the zoning law, there's no prohibition. If there's prohibitions elsewhere, or if there's a policy, that's something else. But under the zoning law, there.
So we would just vote on basically the declaration that there is no zoning provision that prohibits signs.
There is nothing for the zoning board to interpret or grant a variance from, because there's nothing in the zoning law that prohibits signs.
If I may say, I think there was a thought a long time ago. I've been on the zoning board on and off for 10, 12 years. They don't want signs, business signs. There was a whole thing about people putting signs on their house because they were a real estate broker or something like that. And a number of years ago, there was sort of a big flap about it. And I think maybe that's why everybody's confused. I mean, there's signs and there's signs, two different kinds of signs.
Yeah, that's a confusion, if in fact there exists a confusion that the village board will have to address.
Yep.
There's nothing in the zoning.
But there's nothing for the zoning board to address.
No.
I mean, as far as I'm concerned, it's rather, we're gonna uphold John's decision that they need to go to the BAR.
Yes.
Well, that would be a board vote.
But is there a board vote on that second matter just to be clear that there's no prohibition in the zoning against signs?
I think that it's a wise decision to make a formal determination by vote that the board the determination would be that there is nothing in the zoning law related to prohibition of signs for the zoning board to either interpret or grant a variance from. So you would essentially be not upholding John's determination as to the zoning law on that issue.
And that would just save time in case the BAR said, well, actually, the park doesn't allow signs and kicked it back to us.
Yes, there's nothing to kick back. There's nothing in the zoning law that you could opine upon.
I don't understand why we need to opine on something that's not in the laws. That makes no sense to me.
Because
Absolutely no
John
sense.
Made a determination that's on the record that has to be addressed, right?
Yeah, John did send a determination to the applicant that no signs are permitted. The only way to appeal John's determination is to appeal it to this board. This board's opinion and determination would be that there's nothing in the zoning law that prohibits signs, and therefore you would essentially reverse John's determination based on nothing in the zoning law. That makes sense?
Yes.
We're voting to uphold, and then we're essentially voting not to uphold.
Right.
Okay.
Yeah.
All right.
Yeah,
That-
there's two
There we go.
determinations and we'll consider them
Yeah,
separate.
okay.
So the first motion would be to uphold John's determination that the applicant must go to the BAR for sign approval under 100-54.
I would like to make a motion to uphold John's determination that they need to go to BAR.
Second that.
Agreed.
Okay, take a vote.
Aye.
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 So 5-0 to uphold John's.
And presumably this would be applied to anybody putting up signs anywhere.
Right.
Correct. That's would be my view.
And then the second question before the board would be to uphold or reverse John's determination where he said that no signs are permitted. And there's nothing in the zoning law that says that.
I'll make the motion to reverse that determination.
I'll second that.
All in favor?
Aye.
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 Thank you for your time this evening.
Okay.
Okay, so I'll draft a determination before the record.
Right.
Jake, before we start the next one, I'm going to recuse myself from the next application as a governor of the Tuxedo Club and co-chair of the Rackus Committee.
Have a good evening.
Thank you.
All right, the next matter of appeal is the application of the Tuxedo Club, 1 Westlake Road, Tuxedo Park, New York, tax map number 107-1-3.2, seeking relief from the following section of the Village Park, Tuxedo Park zoning code, Village Code 100-21-1L, exterior lighting. No new installation or use of recreational lighting shall be permitted in the village. For the purpose of this section, recreational lighting means light fixtures used to illuminate courts, arenas, fields, tracks, and other outdoor recreational areas. And an outdoor recreational area means an area designated for active recreation, including but not limited to baseball, soccer, football, golf, tennis, swimming pools, equestrian, and other similar recreational activities. Also seeking relief from Village Code 100-18A, fences. No fence over 2 foot 6 inches in height shall hereafter be erected without a building permit and the approval of the Board of Architecture Review in accordance with Article 8 of this chapter. Any fence erected in the front yard shall not exceed 4 feet in height. Any fence erected in the rear yard or side yards may not exceed 6 feet in height. No fence shall be located closer than 5 feet to any roadway, nor closer than 2 feet to any property line. Notwithstanding the foregoing, no fence shall be erected or maintained which will interfere or interferes with the light or air of an adjoining lot or building thereupon. Wherein this application, the maximum permitted fence height in the rear and side yards is 6. The pre-existing fence was 10 feet and 4 13-foot high sections are being proposed. Proof of mailings.
Twenty-eight neighbors were notified. Twenty-two return receipts were supplied, and one was returned possibly with an incorrect address.
Who is going to present for the applicant?
I'm Jeff Greenbaum. We've never met. Been in the park for maybe 4 years now. And Tim and I are here to talk about the application club. I think we're planning on just talking about. Is that the plan for tonight? In terms
Well,
of-
I think the thing is we have everyone here, and I think it's kind of, people are here, and I think it's important to kind of hear from everybody. So I would present your whole application as you see it, all right? And then we will take, we'll open the meeting to the public, we'll let the public speak and handle it that way, okay?
Great. So I guess we're here to talk about the new paddle courts or paddle court, depending on which side of the ocean you're from, and you're familiar with the courts and you've
Yes.
seen them and all that. I think they've been tremendously popular, and people are really excited about them at the club and in the community. And we've got sort of two issues that we want to talk about, right? The first is that there's a question about a variance for the elements of the side, the tops of the fence, the tops of the ends of the club, the ends of the courts, because they're over 10 feet. And then the second question is, what about the lighting? And could there be lighting for the courts for a certain period of time? So, I think one of the things that is helpful to think about as we talk about both of these issues is the location of these new courts. They're in the center of the club, in the center of the tennis facility. They're surrounded on 3 sides by other tennis courts, by the tennis house, by the parking lot. And then, where it fronts the lake, obviously it's below ground level. So, in terms of where the placement is, it's kind of relevant in terms of thinking about what the impact would be on the community and the environment and things like that. The second thing that I think is helpful to think about is that the courts themselves are actually smaller in terms of footprint than the existing court that was there before. Tim and I were working out the square footage earlier today. It's probably about almost 3,000 square foot less of space. So overall, the structure is less than it was before. So I was thinking, and I'm really here just as a member of the Rackets Committee on behalf of the club. Happen to be a lawyer, but I'm not here as a lawyer. So I'm an entertainment lawyer, so I have nothing to say about real estate. But I'm fascinated to hear about all these rules. So what I think I was just going to do is go through the factors and sort of give you a little bit of what our feeling is about how they relate to this application for variance. So starting off with the fence height, the first factor is will there be an undesirable change in the character of the neighborhood? It doesn't seem to us like there will be an undesirable change because the courts are in the middle of an existing tennis facility, because that most of the fence most of the structure itself is lower than the 10 feet that was there before. All we're really talking about is the sort of the two ends of each of the paddle courts, which are a few feet higher than 10 feet. I know that there's a question of whether even the fence law applies here, because whether it's a fence or it's a structure, but that's, I guess, for you guys to sort out whether you think the fence law actually applies. We're talking about a very, very small portion of the courts where we're going to be over that 10 feet. It's, again, just those small sections. Also, if you take a step back, I did a little bit of a drive around different parts today and sort of looking at, does that sort of section that's above the 10 feet, does it change the character of how you look at the facility? And at least it seems to us that it's really in character with what the current tennis facility is right now, that the height where it goes above is consistent with other things that are a little bit higher than 10 feet in that area. So it doesn't seem like there's an undesirable change that's likely to really occur. Can the benefit be sought by some other method? I mean, these are padel courts, they're standard size. Tim could talk if you want about, they're based on the sort of the way that these courts are constructed and the way that the size of the walls need to be for the play. And so we're just taking a standard padel court and putting it there. Is the requested variance substantial? It seems to us like that the variance is pretty minor. We're talking about an overall structure that's much smaller than the structure that was there before, and we're just talking about a height that is a little bit above what is there in a very limited portion in the middle of an existing facility. Will the change have an adverse impact on the neighborhood? And I think we don't think, for the reasons we've talked about, that it will have an adverse impact. And then, was the difficulty self-created? I mean, the difficulty was self-created in the sense that we have this world-class athletic facility and we wanted to add the padel courts to it, which is the fastest growing racket sport apparently in the world right now. And I mean, what we've seen is a tremendous amount of excitement. I know you've gotten lots of letters about it. I admit that I've been playing a lot of padel in the last couple of months since it's been built, and I think that it's been this incredible addition to the club, and we've seen this incredible response to it, both in terms of all the rackets players, all the non-rackets players playing it. We've gotten reports that people who are not members of the club are making inquiries about joining the club because of paddle. So there's a lot of excitement about it. So yes, of course, the problem was self-created in the sense that we wanted to add this new sport to it. But other than that, I mean, the court is the size that it is, and in order for us to have it and to play the game properly, we kind of need to have the fence the size that it is. I will say, though, that some really good planning went into the location of it, and that of all of the places that it could have been, it was placed in the place that would have the least possible impact on the surrounding environment. So that's kind of the fence issue.
All the letters that we've gotten, none of the negative ones mentioned the fence. Okay, so that doesn't seem to be. Yeah. So that doesn't seem to be an issue.
And I think, I mean, you couldn't play padel
Without the fence.
if you had to lower the fence, it would not be a regulation
Right.
court. So I mean, the impact of our decision is substantial on whether we allow padel or not.
Okay.
And it's also transparent, right? I mean, it's
Right.
Yeah.
Right, and so then to turn to the lighting issue, right? So I think that the lighting, to talk about the lighting issue for a second. So I think what the request is, right, is to be able to have the courts lit until 8 p.m. in the off season, right? So during the summer months, of course, we don't need lighting. People can play till 8 or even later than 8 when it's light out. And so the request here is simply to allow people to continue to play padel as it starts to get darker earlier for the same period of time that they're currently playing it now. And so, when we look at these factors and we look at will it create an adverse impact on the environment, I think one of the first things that we're talking about here is that we're not talking about expanding the amount of time that people will be playing padel. That they'll still be playing the same time of day, it will just be expanding the season when they'll be playing it. The second thing is that we're also not, in terms of adverse impact on the environment, we're not talking about sort of generic street lights that are intended to create a light in an environment and create a larger amount of light.
these are lights that are specifically built for courts to limit the light to the court themselves. And I think that, you know, one of the things that I think has been part of the application, and I know one of the things that Tim has really looked into, is ensuring that when you have these lights, they pretty much are just lighting the facility itself with almost a very, very minimal spillover outside of the facility. You know, so in my mind, when I envision it and I think of all of the other outdoor lighting at the club and the tennis house, that, you know, when you're driving down the causeway or when you're seeing it from other places, the amount of light that would be emitted from these lights should hopefully, and the plan is that it really wouldn't change the overall character of the nighttime lighting during that very small period of time that we're talking about. I mean, I think it is important to understand also that, you know, these would be lights that would only be used up until 8 o'clock at moments when people are playing. They'd be on timers, so they would be turned off, so there wouldn't be that problem of lights being on. And, you know, they would be really limited to that sort of period of time when people are using it during that period of time of year where you'd want to be playing lights at night. So from our perspective, as we think about this issue and as we think about these lights, and we think about that what we're talking about is using them during that period of time that people are playing it now, I think pretty successfully, that we think that it would have pretty much minimal impact. You know, in terms of are there alternatives, I think there aren't really alternatives if we want to allow for nighttime play, or any alternatives would be much more substantial, you know, like building an indoor building and creating a new building where you're doing, you know, which would be have much larger impact here. You know, all we're really talking about here is, you know, you know, can we allow for this amount of light to be during the period of time to allow the sort of the amount of play to be consistent with what people are playing. And it's really fun, so.
I didn't open a public meeting yet. Should we direct any questions to the applicant at this point in time, or should we open the meeting before we
I
direct the
think the
questions?
board can ask the questions first, because the answers may also answer questions that the public has.
One of the, you know, obviously you put together a package for the lighting and you know, have taken it from, I guess, whoever you bought the system from, right, from the Patel Lighting. Is there someplace locally where would it be possible to see the same, you know, same similar lights and what those lights look like?
There's a couple different places in the city. Fidel Reserve by Hudson Yards, they've got outdoor Fidel courts there.
Right.
Fidel House, which was the first Fidel courts in.
But in those locations, there's 5 or 6 courts there with lights. I mean, is there any place local where, or, you know, even in a short driving distance where you may have 1 or 2 Fidel courts with similar lights?
Silo Ridge, probably be the closest.
Where?
Silo Ridge, it's an hour and a half, probably.
Okay.
Maybe not quite an hour and a half. They've got 2 courts up there. They put in 2 courts, and then they've got 2 platform tennis courts, 2 Padel courts. Philadelphia, Marion has put in some courts, Billy Cricket.
Okay.
You know, so in residential.
So in another say country club situation like Marion, all right, or Philly Cricket, you know, we could go take a look at what those lights look like.
Absolutely. Or I can also get the folks down there to videos and things along those lines if you don't want to take a drive.
Do you, I mean, did they give you the lights with the courts? I mean,
Yeah, I mean, we right now, the poles that are in there, we're just storing them there.
Right.
So if I put them in the basement of the tennis house, they're gonna get beat
Right.
up. They're just sitting there. We haven't pulled any wires. There's nothing, you know, so.
But we have the lights.
Yeah.
it all comes as kind of a package.
I mean, one of the things that certainly moving forward would require is that certainly the lights that are being proposed be submitted to the you know, the village, and have the village engineer look at them for compliance with dark sky compliance. All right.
And those in the light study that I sent to John, it showed kind of the spillage and so forth on the courts. And
Right,
there's-
it has it, but they haven't been reviewed by anybody at this
No,
point in
we
time.
haven't
They're
all
just,
been,
it
but-
just, they're kind of just submitted, they're submitted in. Has any, I mean, some of the negative response we have had has also been in regards to sound. And, you know, one of the things that I take a look at is that if we have lights till 8 o'clock, we got noise till 8 o'clock, right? And have you thought about any sort of sound attenuation, you know, to, you know, mitigate the transfer of noise to, you know, the local neighbors?
We've got, I mean, if you look at it from a perspective of the glass goes to the lake and to the parking lot, it's a lot less than it was in the tennis courts. It's the issues of going side to side. One side goes neighbors.
No, it's not.
Hey,
It's twice as loud.
Jake,
Yeah, no comments were, okay, you will have your opportunity, okay? You'll have your opportunity to speak, okay?
That's not true.
Yeah,
I think that, obviously, if it's an issue, there are ways we can address it, right?
Yeah.
right, well, that's kind of what I'm,
What?
I mean, I think
that's,
so, you know, absolutely.
There's two big companies. There's a company called Sound Seal and then there's a company called Acousta-Block. Acousta-Block is the biggest provider of sound attenuation for pickleball. And everybody's heard about pickleball, right? So our sound, you know, and to speak a little bit, yes, to your house out the side, I'm sure you hear it. And that's the area where we would be.
Constantly, even in the house.
But you could get tennis balls too.
Twice as loud.
So it's out the sides that we would be looking at doing sound attenuation, right? So I'm in the midst of getting all of that information for, not only for the club board, but for this board to be able to show. I mean, it's funny, we just were showing, a couple of people earlier, they had sent a video of, it just showed where the difference from a pickleball court to being around the barrier. So that they've got some products that are out.
no,
there.
I mean, you know, obviously, since before this meeting, I was going online looking, you know, there is alternatives
Yep.
and, you know, and I think that would be something that would be beneficial during the daytime, okay? You know, if the club provided some sound attenuation.
Yeah, and I'm in the midst of, finding out the cost and what would be the best product for us and what would look the best.
so you'll be submitting that to this board for review?
In terms of the products? Yeah, once we get all the information.
Yeah, we'll wrap this up after we let the public speak of where we want to go with that, okay?
I have a question.
Go.
Tim, if I may ask, I don't understand that no building permit was issued for this construction. Why is that?
Our general manager was provided information, we were able to do like for
I
like.
can't hear you, sorry.
Our general manager of the club, Randy St. John, was provided information that we were able to like for like in terms of that.
But it isn't remotely like for like.
It's flawed, it is a racket sport.
It's a racket sport. That's all that's like it.
I don't think I'm the person for you to get angry with. Okay? I was told.
All right, I will ask Randy St. John.
And the board of the club, they've been approval for doing it.
Thank you.
Any other preliminary questions from the board before I open up the meeting?
No.
I'd like to make a motion to open the meeting to the public.
So moved.
Second?
Second,
Aye.
all in
Second.
favor?
Aye.
All right. This lady has her hand raised, can speak.
Is it Kathy Norris?
Tracy Cassie Norris.
Love you, darling. Okay, what concerns is the village code 100-21.1, exterior lighting. As you know, there is a complete prohibition of such relief sought in this application as the aforesaid village code provides. No new installation or use of recreational lighting will be permitted in the village. For purposes of this section, recreational lighting means light fixtures used to illuminate courts, arenas, fields, tracks, and other outdoor recreational areas. And an outdoor recreational area means an area designed for active recreation, including but not limited to baseball, soccer, football, golf, tennis, swimming pools, equestrian, and similar recreational activities. Boom.
That's what they're requesting a variance to for a period of time. That's why we're here.
But this is prohibited by the village, what they're asking for.
You can ask for a variance.
They can ask for a variance.
Well,
I
which is
mean,
what
there's a
they're
lot
doing.
of other things that are
I can
prohibited,
ask for a
fences,
variance for
fences
12
above,
horses at my
fences
house.
above 6 feet is, you know, you need a variance,
Yes,
okay? And
but
so,
this, it's respectfully submitted and blah, 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 and it is all written by law here in the document that you have. And, I understand what they're trying to do, but what they don't realize is the number of the beautiful houses that are around the lake when these lights are on at night, because it's starting to get dark at 7:30, and these lights are lit up, they're going to lose the value of their properties with these lights going into their houses. And I just don't understand why the club would even consider this. If they want to go there and play, they've got all day to play. They don't need to go play at night after dark. I'm sorry, and if there are people who can't get to Tuxedo Park until after their job, so they drive up here from wherever they are or get to the park after work, I'm sorry, but it's too bad to play that at night. They can play all weekend. I don't mean to be rude. I just think that this is something that is going to ruin the value of the properties of the houses around the lake also.
that's your
Somebody
opinion,
else
okay?
want to speak?
Yeah. No one else?
Does anybody agree with me?
Yeah.
Okay, thank you.
May I speak from back here?
It'd be easy, probably they wouldn't be able to hear you online, so we'd better off to just come. Yeah, I think if whoever comes up to speak, even if they either sit there or stand there, it'd be fine.
You have a copy of this, do you not?
I have a copy of that.
Okay,
Yes,
because it has the law in it.
I understand.
Thank you.
I have it. We have a copy.
I just turned in my letter to the BZA about this tonight, but I do have an objection as well to the height of the glass wall. But if you'll allow me to read my statement, and also our neighbors right across the street, Claudia Holtz and Bill Lamb, wrote a really great letter, and they cannot be here tonight. And I'd like to ask your permission to read that into the record as well.
You have.
Thank you. Honorable Chairman and members of the Tuxedo Park BZA. My name is Jeffrey Marchand, and I am accompanied by my wife Dolores Marchand. We reside at 36 West Lake Road in Tuxedo Park. Dolores and I have owned our home and have resided in Tuxedo Park as full-time residents for 33 years. We have also been members in good standing of the Tuxedo Club for 31 of those years. Our children attended the Tuxedo Park School and had the benefit of growing up in this beautiful place, enjoying the peace and tranquility that everyone finds so special. After asking residents over the years what drew them to Tuxedo Park, these are the qualities that are most often mentioned. We are attending this hearing about the proposed zoning variance sought by the Tuxedo Club to install outdoor court lighting at the Padel Court. Obviously, you are aware that this is specifically not allowed by our zoning laws. Allowing such a variance will set a dangerous precedent. We are a part of the group of property owners closest to, adjacent to, and thereby most impacted by the Padel installation. For perspective, our home is approximately 200 yards from the court, but our neighbor across the street, Ted Wong, is less than 100 yards away from it. I submitted our comments in writing to the Board of Architectural Review at their meeting on July 25th, 2024, and also read them into record by Zoom call. The following are the main points of that letter. The exterior lighting poles and lighting fixtures were never in the plan approved by the bar. The club nonetheless erected the light poles in contravention of the original approved plan. We assume that the reason for exterior light is to extend the operating hours past the current end time of dusk, as stated on the Tuxedo Club website. As property owners located so close to the club and to those others that could have lights glaring at their property, this will have a very deleterious effect on our quality of life, general well-being, and to our property values as well. The Tuxedo Park zoning code exists to protect the interest of property owners, not to protect the interest of racket sports players. We, the adjacent property owners, will suffer loss of property values as well as loss of quality of life due to the negative aspects of this installation. So we therefore support upholding the zoning laws prohibiting this exterior light installation. Aesthetically, the light stanchions and the lights and the glass cube structure itself do not match, complement, or otherwise add to the beauty of the classical architecture of the Warren and Wetmore design tennis house. In our opinion, it substantially detracts from it. Before the Padel structure was built, the club cut down a significant number of trees, high shrubs, and other plantings that served to help as a sound barrier. To date, they have replanted practically none, or I don't see any replanting, of those trees and shrubs to help sound mitigation. Nor do they attempt to control what goes on over there. We hear all kinds of whooping and hollering and kids yelling and screaming and dogs barking. It's amazing, amazingly bad. Additionally, we have since discovered that the club erected the glass walls of the courts to a taller height than was approved in the original plan. We believe that they should be compelled to lower the height to conform with the original plans. Okay, those were the points of the bar letter. Now, I'm going to continue on. The way in which the original Padel plan was represented by the club to the village raises a host of questions. We, as direct adjacent property owners, were never notified by the village of these plans. As a normal course of action, we receive notifications from the village when it concerns something that affects the adjacent homeowners. Not this time, which raises the question as to why. We therefore were not able to perform our due diligence, after which we would be in a position to offer our voice in the matter. Now that these issues and questions have surfaced, research that would have been done at that time, had we been notified, would reveal that problems and issues with the Padel courts have been documented numerous times in locations worldwide. Another key issue is that the building inspector allowed the construction on the basis that the Padel courts are like use to the existing lawn tennis courts. This is a spurious claim. A lawn tennis court does not have a wall surrounding it, nor did the original court have any light poles or lights of almost 20 feet in height. How could construction of these courts be deemed like use? We believe that there are many unresolved questions about how the original plans from the club were presented, and then subsequently how they were decided upon and approved. As Tuxedo Park property owners, it is our right but also our obligation to pursue answers to these questions. We have quality of life, property rights, and property values to protect, and we intend to move forward to appeal the original plans and will do so vigorously to defend our rights. Thank you most sincerely for hearing our concerns regarding this matter. Signed, Jeffrey Marchand and Dolores Marchand. Now, if you'll allow me, I would like to read the statement by Claudia Holtz and William Lamb. There are neighbors at 26 West Lake Road, and they're even closer to the noise and commotion than we are. John, as in Linwood. We are writing to register our strong opposition to the proposed lighting installation for the Padel courts at the tennis house. We are direct neighbors of the Tuxedo Club tennis house, living at 26 West Lake Road. The bright lights and sounds of the courts in the evening will significantly detract from the enjoyment of our property and negatively impact its value. Obviously, when we purchased our home, we were aware of the possibility of noise coming from the tennis house activities during the day. So were we, that's an aside. However, we were comforted that the village code with respect to recreational lighting prevents the use of the club facilities as an outdoor recreational area after sunset. The board should not permit our neighbor to bypass this restriction despite the unqualified prohibition in the existing code and the strong objections of the immediately impacted neighbors. We are aware of letters of support that others have filed at the village office. However, these homeowners are not adjacent properties of the club and will suffer no adverse impact to the enjoyment of their homes. Consequently, their views are not relevant to any consideration of the lighting application. It is incumbent upon the board to treat all residents fairly and consistently. The proposed change would be materially detrimental to adjacent residential, let me start that over. The proposed change would be materially detrimental to adjacent residents' properties, and the requested variance is substantial in that it will change the entire nature of the facility's use. Significantly, the relevant code seems specifically written to protect surrounding neighbors of a recreational facility, in parentheses, i.e. the tennis house. As we read it, variances to this prohibition should be granted only in extreme circumstances where there will not be any adverse on surrounding properties and when the circumstance that violates the code is not self-created. The variance requested by the club does not even come close to satisfying these requirements and consequently should be rejected. Please share this communication with the Tuxedo Park Board of Architectural Review and the Tuxedo Park Board of Zoning Appeal. Sincerely, Claudia Holtz and Bill Lamb. Thank you very much.
Chris? Would you like to say?
I don't know everyone, but I'm Chris Cummins. I'm a full-time resident of the park, and I'm a member of the club as well. And I'm a newbie. Well, I'm
Chris, if you come forward here, I think we're still having issues with that.
Sure. So I'm a newbie. I've only been here 8 years. I love the facilities. I love Tim. I think the Padel is exciting. It's the most, it's catching like wildfire, but Padel will not be diminished without outdoor lighting. You can still play. You'll still have, even during the winter time, you still have 8 or 10 hours to play. With lighting, the quality of life that every resident of Tuxedo Park currently enjoys will be diminished. One of the things we love most here in Tuxedo Park, one of the most unique things, and I didn't know that I was in for when I got here, is the beautiful sky in Tuxedo Park. It's absolutely pitch black, and the constellations and the stars you see are brighter than anywhere for many, many miles around. And that will be diminished. That will be compromised if we allow lighting for the courts, because then you'll be setting a precedent. Then, residents, et cetera, others might claim that, or maybe you need them for tennis next. And I guess lighting brings additional issues, as was already mentioned. And the precedent, I think, there that is very interesting to take a look at is the paddle tennis that's out by the golf house. And I understand the folks who play paddle or have a great time playing. It's a loud, boisterous, fun activity and atmosphere. Loud music is played. It's a big party. It's a lot of fun. I really would be disappointed if that were to come to our front and back doors right here in the middle of the park. And I think it's inappropriate. But if we allow it, we're peeling back a little bit more each time one of these variances is given, whether your home is on the lake or the homes that are just around the park or you're driving by, we're peeling back a little bit more of what Tuxedo Park is really all about. And that is disturbing to me. And then finally, there's other precedents as well, because we actually applied for the same variance and were denied by the board in 2017 because someone on the board made a very good observation that with lighting close to Tuxedo Road, cars going by could be blinded by such light being thrown out into the road. That was my house. That was 80 yards. I'm 80 yards off of Tuxedo Road up on Continental. In the back of my home where I wanted the lighting for the patio backs up on Terrace Road. I have 34 trees between myself and Tuxedo Road.
That was the board's determination, and I lived with it. If you walk from the Padel courts to East Lake Road, it's 74 or 75 yards. And there are 2 trees blocking that light. So already the precedence is in place. And if you need more precedence, you can take a look at the paddle courts, because it just, you know what, it's a fun atmosphere. It's appropriate. Many people enjoy it. But I would submit it would be inappropriate in the middle of Tuxedo Park.
Thank you.
Thank you.
Loris?
I would agree with that. I have letters, I'd like to read from 3 of my neighbors that asked me to read them.
Okay, yeah, I have both those.
Okay.
The first one is from my neighbor Ted Fong, who is exactly directly across the street from me and right next to the courts. Has a view right to the courts and probably the most noise from that.
It's not on part
impacted.
one.
He's almost there, right? So he's very much impacted. Dear Chairman and the board of the BZA, the village codes are meant to protect residents of the village. The rules are in place so we can all enjoy the comfort of our homes and our neighborhood. Recreation is fine and good, but it should not and cannot come at the expense of other residents. The Tuxedo Club is in the middle of a residential village. The village code explicitly stated, no new installation or use of recreational lighting shall be permitted in the village. These codes are designed to protect all residents, and in this case, they protect me as a neighbor living next to the club so that I get to enjoy the comfort of my home. As a member of the Tuxedo Club, I understand why some members want the recreational lights installed for their enjoyment. But enjoyment of the club facility as a privilege to its members is not the issue before the BZA. Enjoyment by some should not come at the expense of others, because in the end, it is an expense to all of us. That's what codes are for. I ask this question for all the stakeholders involved. If your next door neighbor wants to install recreation lights, which you oppose, do you hope and expect the village to hold up its codes? That's why I strongly oppose granting this relief. Sincerely yours, Theodore T. Wong, 37 Westlake Road. The next letter is from Cindy Booth at 262 Tuxedo Road. Good afternoon. In response to the letter I recently received regarding the application by the Tuxedo Club for a zoning variance in order to install extensive outside lighting to illuminate their padel courts on club property, I wish to express my strong disapproval of granting that variance. As a very close neighbor of the Tuxedo Club, I would be directly affected by that proposal. I pay very substantial property taxes on my 6.5 acre parcel of land and expect to have the quiet enjoyment of my property respected in return. In my opinion, the Tuxedo Club does not respect the rights of the many neighboring property owners who are residents and taxpayers of the community, as they consistently permit and encourage activities for club members that create revenue for the club at the expense of the full-time residents. In my opinion, there is absolutely no reason why residents should be expected to have bright lights and noise to tolerate in the evening after 6 p.m. As we all know, noise on and near the lake travels and reverberates. The glare of bright lights, especially tall ones, will be an eyesore to every property owner around the club and the area of the lake. Many years ago, the club paddleball courts were moved out to the golf course because so many residents objected to the noise, to parking problems, lights, etc. that those courts created. At least at the golf course, there are no nearby residents that are affected, and taxpayers are not being ignored and in essence penalized by having their property values diminished by club members and their guests who are frequently not even residents of the community. The Tuxedo Club has making maximum profits as a priority, which is understandable. But since it caters to a majority of non-resident members, I object strongly to this proposal. Please see that my letter is shared among the BZA members. Sincerely, Cindy Booth, 262 Tuxedo Road. And then thirdly, I have my next door neighbor on Westlake Stable Road, Patricia Gavi. Mr. Ledwith, I am writing to oppose the application of the Tuxedo Club to add lighting to the padel court. Said lighting would extend the hours of the padel court and could be used, extend the hours the padel court could be used and thus extend the hours when nearby residents would have to contend with the noise associated with the use of the court. I am also concerned with approval of this lighting request that it could set a precedent and that the club could next request lighting for the adjoining tennis courts. I urge the bar to deny the club's request. However, if the request is granted, please consider strictly limiting the hours and days lights can be used. Said lights should not be permitted to be used beyond a very limited time period, certainly not past 8 p.m. at night. Patricia J. Garvey, 65 Westlake Stable Road. And I will add that it is not like for like, and I have no idea why we never got a notice that it was put in the first place. It is doubles, 2 courts of doubles, and the sound reverberates, and it's like hearing gunshots, and it's coming on our porch, our garden, our house, inside our house, and it is severely impacting our lives. My husband and I are both classical musicians. I'm a former symphony and chamber music musician, and I value quiet time and what I hear. I don't like it at all. And I feel like it's an invasion of our life. So that's my opinion. Thank you so much.
Hello, my name is Kurt Muller. I'm 12 years old and I live on 12 Patterson Brook Road. Just while I start, I just want to clarify that the padel court and the lights are going to be on in the afternoon and be turned off at night, not be running through the night. And here I stand behalf on most of the children under the age of 18 who enjoy padel. I think it would be a great thing for all of us kids who play racket sports, who are just getting into it, to have that opportunity to play the sports maybe after school once we get our homework done. I could 1000% envision myself and a couple of other kids that I know that would definitely enjoy like finishing their homework and then coming to play padel with each other or with friends that we have. Thank you.
How'd you get in here?
My name is Ann Guathme. I was in front of the BAR and the BZA many years ago while Greg Baird was trying to put in his sport court lighting. So that took about 5 years to get through, but he did it. He observed the hours that were asked that the sport court not be lit up. We're on a major flyway here. Birds are migrating. The prevailing wind from the lake is not going towards the lake. It's going down our corridor. And I do believe we did pass view sheds and protective corridors, and I don't know how you will feel about that, but it's something to take into consideration, and perhaps we can use as the bargaining chip the hours that it is not to be lit. And whether it's automatic on a switch, so that somebody physically who may not be there turns it on and turns it off. That's it.
Anyone else like to speak that's in the audience?
I just think that I was absolutely amazed about what a wonderful job was done with that Padel court. But I think it just does not need light. I mean, I'm sorry, people don't play in the winter. And someone said something to me where I thought be done at 7:30 or 8 with light. But that's kind of November, December, and January. And I don't think anybody's going to be on that court playing. We have such a wonderful history of classical things with our court tennis and our squash and our racquetball and our all of that. It just is, and we are really kind of we're on the National Register of Historical Places,
And I also think that if, I think that the Delacorte's going to be, everybody's having a great time with it. I love to see everybody having a good time. My husband and I have been very involved and here for almost 60 years. And we lived at the tennis court. I haven't been there recently. I don't play anymore. But I also am concerned that I was surprised that this all happened and no notification from the club that it was being done. And I get things from the golf, and I'm not a golfer, real, I'm not a good golfer, a long time ago. And a long time, that it was, they all let people, the members know what's going on. And there was no notification, maybe I missed it, but I didn't say anything about this until it was a finished product and the arms are there for the lights. They haven't been connected yet. But also, I think that if it happens with that little court, that fun little court that everybody's having such a good time, is that why then can't the other 5 courts or 6 courts that we have there, why can they not have? This has been going on well over 100 years, and they haven't had lights. And if one is, I'm just sure that if that happens, it'll set a precedent, and the whole thing will be lit up.
And the pool.
She's right.
Right.
Yeah, she's right. But I love casinos.
Yep.
And I love the club, and I think it's a wonderful, fun thing to have. I think that people can play and have fun with their young people and their friends and not have lights. I don't.
I just have one question, and it's really kind of a procedural question. I don't understand when there is apt to be controversy about this, why some preliminary work is not done. In other words, if you need variances, why don't you come and ask for the variances before you build it, then ask for the variances after you build it? And also, it was already mentioned that there was a paddle court put up near the tennis court in the past. And because of the noise of it, and were complaints by the people who actually live where Mr. Wong now lives. And so the club moved it down to the golf course. So it seems to me the club ought to have some organizational memory that putting something like that up here is bound to cause trouble. Where at the golf course, it would not be a problem. And you could have done it, and you can do it now. You can move it down there.
Move it.
Move it.
Move it. Very good. We'll just get the tennis courts.
I know there were many letters written in support of the courts. Or
Nobody can hear you.
I know there were many letters.
You need to stand up
Yeah.
so the people online can hear you.
No, I just wanted to say, I know there were many letters written in support of the courts, and I'm just wondering if they will be read.
We've read them all.
I mean, if you want, I'll kind of clarify. There were roughly 46, 47 letters. Of the letters, most of them were in support. However, most of the ones that were in support were not close neighbors. However, there were, I think, 4 that were in the district that these notifications were sent out to. All right. And of the negative letters, there were maybe 15, 16 negative letters. And most of the negative letters were from neighbors directly impacted. Okay, so, but there were letters from people who did receive the notifications that in support.
Brian, you wrote one. Do you want to read it?
Well,
I have a copy
Jane
of it.
has it.
I have a copy of it if you'd like to read it. I have it in my file. Would you like to read it?
No, I think the board has it.
We had
Oh,
Todd.
You were just asking, are they gonna read any, Brian? Why don't you read yours?
You want to read yours, Brian?
No, Brian, right here.
She doesn't want to.
If you don't want to, you don't have to. We've read it, okay?
She said,
No, she said, are you gonna?
she said no. Are you deaf?
You wanna read
No,
it? You're
She
signed on
said,
it
she
too.
asked for any letters that have been.
Todd?
She asked it, not me.
Well, I,
Hold on, Sarah. I have it if you'd like, one of you would like to read it.
I am Todd Unitzy. I'm a neighbor of the club and have been here since 1996. I am the fifth house, to so I consider myself adjacent. And I value all the comments everybody, I think, has made quite sincerely. And I think there are a number of issues here, one of which relates to the height of the glass. So if you're going to have the game, play the game correctly. And whether if that glass is 2 feet higher than what a fence that may have been there in the past, I don't think changes materially the structure being there. If it should be there, but if you're going to play the game, play it. In the past, the club has had a squash court that was made to play in the space that it was allowed, and it didn't play correctly. So if you learned there and you took that skill set to another place, you would have mislearned the game. I think that if it is allowed to stay there, the height should not really be an issue. That should be something you should consider the variance for. If there is an impact on sound to neighbors, which clearly there is, okay, and that whether it should have been foreseen or whether it can be mitigated, the club should listen to that and do everything they can to mitigate the sound that's coming from the club, regardless of whether it's from that court. And if they're taking out trees, they should be replanting trees. So they should really consider that, or the soundproofing. I think that Tim mentioned that that's being looked into, and I would echo that. I also hear a lot from the club. I hear mostly from the pool, okay, because now, maybe that's because the glass blocks the sound from that direction across the lake, but I hear boat noise, I hear pool noise, I hear bands that I don't prefer to listen to, okay? Separate issues, okay? And I mean, they're ruining a lot of the songs.
Bad.
But putting back trees that are taken out should be something that a good neighbor should consider doing. Okay, but the game being fun, and whether there are lights, and the lights are going to point down, and I don't see how, if they're off at 8 o'clock, that would just extend the play to what is customary and would give us something to do during the winter months, which when we did move here, I feared the winter months because of what's going to happen. I actually came to really like the solitude and the snow and all that, which I'm sure people do. But give the kids a chance to get their homework done. Give people that are commuting here, not everyone's available all day long, that extra hour and a half, half an hour, whatever it might be in that time of year, I don't think is unreasonable with the technology. And we seem to have the lights, put them up and see on a forget what it looks like in Pennsylvania. What would it look like here? And would you really see light pollution to your property? Because it's dug down, so I think that also does mitigate the height issue. And if it is unreasonable and pollutes the neighborhood in a way that really is impactful, I think that's just, if you don't want the court, then the height is going to be a capper issue. But we've seen so many things built and variances granted for good reason, and things built for perhaps bad. These seem like minor relative issues. The sound, if it's coming out the sides where there's fence instead of the glass, okay, then that is a real issue that I don't hear, but I don't deny that it exists to others. And again, I really stress that the club should be looking into that. But I do support anything the community does that brings the community out. And I've been a member of the club, and I play some of the racket sports. I never played padel, and I see more people there now congregating to play the game than now I've gotten to meet and enjoy that access to. So it's popular. It draws people to the community. I don't think there's any evidence to a property value being, other than opinion, which you're entitled to, being devalued because a world-class facility with multiple tennis games, the equivalent of which there is none in the United States, exists, that draws people to the community. And so I think it's an asset, not a something that devalues properties in any way, shape, or form. So I wanted to, and I had a letter that I had written of support. I was unaware of the noise issue again, so I will, once again, stress that that should be looked at and addressed to the satisfaction of neighboring properties in the community. And with that one caveat, I have a strong support for the court as it exists and being lit properly to allow for safe operation. The other thing, people are gonna play at night, okay? They're gonna play until 8 o'clock and they go home, and then they're not gonna be lit. So then that's gonna fall on the community that didn't allow lights, if that were to happen, to allow people to not see properly and perhaps get injured, and that's another cause. That's why you light the court, so you can see, properly. And if anyone ever grew up, like you had to come in at night because you were out playing stickball or something in the street, like you had to find a way home because, that's when you get hurt. Okay, so the club, I can't believe they would let people play unless it were lit properly for the hours that it would be operating. That's it.
I just have one other question. If they extend the lights till 8 p.m., will there be people at the club monitoring that all those hours, like every day? How does that work? Or is it just the honor system, people go and they're, playing and turning the lights
I mean,
off?
you could have a special time, why don't you answer that?
We would do it just like the Hurlingham Club in London, which is probably the most famous tennis club in London. Hurlingham has a system where you actually have to log in, you get a code, the lights go on for that period of time, and then they shut off. So the system can be set up to where there can be no lights after a certain period of time, whatever that is determined.
And that can't be overridden.
I'll echo that. Okay, the club has a whites policy of wearing tennis whites with collars. And I've gone out with gray socks that I barely even know are not white, okay? And there's a process in place to defend the rules, and in a nice, polite, but absolute way. The rules, they don't get broken, to what I've ever seen.
Well, and the other thing is, 8 o'clock to us is like 7.
I'm sorry, whoever's speaking, I can't hear you.
No one seems to consider that we just want to be hearing these like whacking balls hitting, sounding like gunshots, and people screaming, because that's another issue, that the people that are playing the padel are very, very loud, and they bring their barking dogs and screaming kids, and they're whooping it up every time they hit the ball. It's like, whoop, whoop, smack the ball, scream a little. They don't realize, I'm sure they're having a good time, but it's very, very much impacting our life.
And it's impacting Margaret also. She agrees.
I wear white across the street at the club, so it's really loud. And
Impossible.
I think now because they have a glass on, even louder. Before that, we heard it, but not as loud. Because I've noticed, it's like, why they so loud?
No, I think the club recognizes that I think that some sort of sound attenuation is required here.
I mean, the easy solution would be just to relocate it to golf, and they can play all night there, because there's no one living right next to it. And
I'm sorry, Jake, if people do not come to the front, I can't hear them.
If you want to speak, you're gonna have to come up, because John can't hear.
Okay. My thought is it should be relocated to golf, because people can play all night long if they want there, and it won't be impacting people's lives and dinner hours and peace of mind, so. Because it was brought in without the actual approval, we were never notified. We were never able to go and research what padel is, and we did read that in Europe, they're outlawing them in residential areas left and right, in Holland, in Spain, and in England.
And in France.
Oh, okay, in France.
I would just also like to add one last thing. I don't think that people that don't live across the street from it or adjacent to it get the impact. And I invite any of you, if you'd like to come sit on our front deck sometime and listen to what's going on over there, you'll see what we need. And we have a direct line of sight to where those lights are gonna be. So, okay, they're nice and they're pointing down, we're still gonna see them. I mean, they may not be, like lighting up an airport runway, but they're gonna be shining through our living room windows, our master bedroom windows. It's gonna impact us, and I don't think, if you don't live right across from it, I don't think you really get it completely.
Melina agrees with you, and she's across the
All right,
road.
hey, come on, no, all right, you've had your piece,
Yes, sir.
okay. Anyone else like to speak? All right, I'd like to make a motion to close the public hearing.
So move.
Second.
All in favor?
Aye.
Aye.
My feeling kind of from the start of this is that, there's just too much information out here that we really need to assess before we could even move forward on it. I mean, we could look forward and take a look at the fencing if we wanted to approve fencing, but certainly we would not look at the lighting. I think that it's kind of important for the club to, kind of, if for moving forward, that they really need to get a lighting consultant to at least, put the lighting that's proposed into something that can be reviewed by the village engineer. I think that you also really need to take a look at the sound attenuation, all right? I think that's and that's kind of important whether there's lights or not, all right? Obviously the quality of life from the people that are surrounding here are, do seem to be impacted by it. And I know the club wants to be a good neighbor, and I think that, you could put sound barriers, on the fences of the tennis courts, all right? So you could still kind of leave that court open and do it on the tennis courts, and then plant some trees maybe too, so.
Casey, the golf course superintendent has it in his agenda to do that in the fall, once it gets done with the golf.
Yeah, I mean, it's not a time to plant trees now. You plant the trees in the fall, so.
It's already on his agenda, and we talked to John about that when we were talking about taking them down to do the drainage.
I think we should address the fence thing tonight, because to me, that's an existential thing, right? If that doesn't get approved, you really can't play the game. So it makes the lighting completely moot.
Right.
So if there's enough information around that, I would suggest we do that.
I would not suggest that.
Okay.
I don't think you should separate one variance from the others in this case, because if you grant, for example, the fence variance, then it's an indication of the board's willingness to perhaps grant the other variances when you might not be. So is there, I mean, is it
Not
then?
really, not really, because the game can be played without lights, as you know, and it, but it kind of needs the fence to be played.
Yeah, I mean, the question is,
So,
it a fence? I
It's
mean,
regulation.
structure. Right.
Isn't it being played on now? Because I saw people.
It is,
playing.
being played on now, so they're coming to us kind of after the fact for approval on the fence.
So
After
while,
built.
while there's a ZBA appeal pending, violations are held in abeyance. So there's not gonna be any, John is not gonna say you have to stop playing.
Right.
Because they've come to this board for a variance, and until you make your determination, everything else is held in abeyance, if that's the concern.
Well, no, it's more, at least, if there's a lot of work to go into researching things like sound abeyance and understand the lights piece, but if you can't have a regulation court, those things don't matter, because you.
Well, if the club determines that they don't want to do all these things and they want to leave it as is, then they could just come for a variance on the fence,
Right.
not the lights.
I mean,
I think that's where.
nothing's gonna stop the
Okay.
court being played right now.
Right.
Because they have applied for a variance.
Okay.
So enforcement is in abeyance until you make your decision.
Excuse me, is the glass, the glass is 10 feet, I believe, isn't it?
Just shy.
A little bit less.
And just the top, either side of the court, that's kind of like the old fencing. which is up 3 feet more.
Right, the only
3
thing, no,
feet,
it's
not
only,
all
it's
the
the
way
back, it's the
around.
back of the,
It's
it's
just
the back of the court that
It's
has
the
the
back and
13,
the front of
yeah,
the
the
court.
back and the front of the court that have the 13
Of-
feet.
of,
And it's
uh,
just, it's like a
both-
section, like,
And there are 2 courts there, so is that, I can't, is that so with both courts?
yes,
Or is it one,
no, it's for with each end of each court has a 13-foot
It
fence,
does.
right. It's just across the back.
right?
Why
Which
are
is the
there
width
not
of the court.
decals to prevent bird strikes on there? I didn't
That's
see
an,
any when I walked
that's
by there.
another issue that I believe that they are looking into right now, is how to prevent it.
We had put up 4x8 decals from, I don't remember the name of the company. And, we also have gotten the decals from suggested by the Audubon Society,
Okay,
which we'll be putting up. Those, the big 4x8 ones didn't stay on the glass. So we're gonna put up the Audubon ones, suggested by the Audubon Society.
okay, so you're investigating that and you're
Yeah,
gonna
we
come
have
up with
all of it,
something.
yeah, exactly.
Oh, for the bird.
Correct.
For the birds.
Yep, yep.
Yes, there are a couple letters in here that only address the birds, too.
We were just in London and the Queens Club has, we're gonna do, they have basically quarter-sized dots at about 4 foot every 2 feet. And they say it's working well, but it's also a different location. Queens Club is middle of London. So they're not getting the birds that we're getting here. So we're going to do what the Audubon suggested. They're a much smaller dot, but they're every 4 to 6 inches. So we'll get those up and see.
Has it been an issue to date with any birds?
I talked to Carlos and Dean. We've had, over the last month, I think 4 birds have hit the glass, is what they've said. So they'll see it in the morning when they do the cleaning. So there are definitely some issues. We've had them hit fences in the past too. So the glass obviously is more of an issue than the fences were. When they're getting chased by a hawk, I'm not really looking at the fence, so.
The migrations are starting right at this time of year though, I think Sunday night, so be prepared for more of that.
Well, if we're not gonna vote, then we close the regular meeting, that's the only thing.
You can adjourn this, the next meeting. You can adjourn this application to the next meeting.
I'd like to make a motion to adjourn this application to the next meeting, or whenever the club is prepared to come before the BZA again.
So move.
All in favor? Aye.
All right,
We do have one other matter, is that the approval of minutes to the meeting. Can you read it? Dave, can you come back? You're out of limbo.
Approve minutes.
If you haven't read it, we could approve the minutes without you
Yeah.
having read them. You could just not, you just abstain.
You just need 3 people to.
Right. Yeah, I'd like to approve the minutes for April.
Excuse me, I believe you did, Nancy, do the first one that we have to approve because we had a conversation about it. So you can vote on
You
the
made
oldest one.
changes to it.
Oh, I made changes. Well,
So you
good.
must have read it.
Well, I did, then. I
Right.
obviously didn't approve of it.
You made the changes to it.
Huh. Okay, well, I don't happen to have it here.
So I'd like to make a motion to approve the minutes from February 7th.
Second. So moved.
All in favor?
Aye.
aye,
Then I would also like to make a motion to approve the minutes from April 3rd.
Second. Aye.
All in favor?
Aye.
aye,
Then I'd like to make a motion to close the meeting.
No move.
So move.
aye.
Whew.